The time is 7 p.m. and I am calling this session of the Legislative and Legal Affairs Committee to order. The date is December 11th, 2025, and we are meeting with one item, order number 25-100-9415, proposed change to city charter relative to section 59A for filling vacancies in the office of mayor and city council. And we had met one time previously about this, and then we have now continued to tonight because there were some pieces of language that the committee and other councilors wanted to discuss further. And so I'm going to read an email from Council President Ossing dated Thursday, November 13th, 2025. Councilors, based on feedback from the 11/13/2025 L&L meeting, attached is draft language to fill the vacant ward council seat. And so it breaks it down to the change would be if the vacancy occurs in the first 12 months, it would lead to an election. If the vacancy occurs in the last 12 months of the term, the remaining councilors would appoint. And that is signed Mike Ossing. And the proposed change, so the amended version would be vacancies in the ward councilor position. If a vacancy occurs before the last 12 months of the term in the office of a councilor elected by and from the voters of a ward, the city council shall forthwith order an election to fill such vacancy for the remainder of the unexpired term. If a vacancy occurs at any time in the last 12 months of the term in the office of a councilor elected by and from the voters of a ward, such vacancy shall be filled forthwith by a majority vote of all remaining members of the city council for the remainder of the unexpired term. So with that, I will open this up to any committee members who have comments or. Councilor Roby?
Thank you, Madam Chair. I thank Councilor Ossing for sending this. I think it's a good compromise. I still am not all that thrilled about having to vote for a elected official, but it hopefully doesn't happen. But if it does, while I'm a councilor, at least it makes it easier and we know what we're doing. We don't have to keep going for the legislator to try to get a change done. I know we have to ask them for a home rule petition to make this permanent, but once it's permanent, then I think this will solve our problem. So I would support this, and I don't know if you want a motion to approve the, you're not on the committee, so you can, but I can move to approve first, and then you can comment. I move to approve the suggested changes as to get us to the language that you just read.
Okay, a motion has been made and seconded, and I'll open it up to further discussion. Councilor Doucette?
Thank you very much, Madam Chair. So in 2015, Bob Page passed away in October, and because Bob Gregoire told me the day after that he was buried that, Bob Page died and was buried yesterday, which was the same day my mother was buried. So my concern in the wording as being close to the election, okay, the decision will impact the election, right? How the council votes. If someone dies in September, October, during election season, okay, then that vote can undo the balance of the voters, because a lot of voters will say, oh, he was voted in by the council, so I'm going to cover him. Okay, so I'm concerned about that wording or that coverage here, which is why I was flagging it so early, because I think that's an important part of this. We shouldn't be weighing the scales with this type of decision. And I'm not necessarily sure how to solve it, but I do think something of the order of, if, as an example with the Ward 7 counselor, whoever wins the election in November can at least finish the rest of that term, okay? Or the person who is nominated, if, can't run for the, for the follow-on term. Okay, so that way, it's a cover, and it keeps the politics out. So, that's all I have to say.
Thank you, Counselor Doucette.
I know everybody hasn't spoken, but can I just respond? Because I think it's important to remember.
Absolutely.
The language that we sent off to the legislature for the current vacancy, I don't remember the date, but I think we did it back in May or June. It took them up until, what they finally send it in? November.
November 12th?
Which is basically what we wanted to do, was to appoint whoever won the election, because at that point, we felt that it had been. But if a counselor passes away in January of a year that there's going to be an election, you don't even know who might want to run for office. You need to have somebody in that seat. I don't want to have a repeat of nobody being a counselor for over a year, longer than a year, when there is a vacancy. I think the sooner we can fill it, the better. And yes, there might be a influence because they are sitting as a counselor if they decide to then run for office. But people could say, hey, that person's not doing the greatest job, so I'm not going to elect them. It'll be up to the ward to decide who then continues. So I don't personally see a problem with this, and I don't, especially if someone passes away in October or November, they're only going to be replacing them for a couple of months, and would the best choice be to elect, if it's November, appoint who was elected to do it? Yeah, probably, it would make it easier, but the further out from that you go, you don't know who's going to run for office. So that's.
Thank you, Counselor Roby. President Ussing.
To help maybe alleviate Counselor Doucette, so we all voted for a replacement school committee member a little while ago, so that's given that individual a leg up on, if you consider that. But I think Counselor Roby's correct. If your performance is good or bad, I think that would play into it. And the current charter for at-large counselors, whether they die January 2nd of the first year or November 1st of the second year, this body gets to appoint one. So I understand I definitely understand the concern from a ward race perspective, but I don't think it's challenging, because what we're trying to do is fill the seat quickly, because the way the current charter reads is the first 18 months we hold an election, the last 6 months, so try to fix that. I think this is a good compromise that Councilor Roby came up with, to just make it, hey, first 12 months, we'll hold that election. It gives the clerk's office plenty of time to run the show and get everything ready. The last 12 months, we'll do it similar to what we do for at-large and let the council make that decision. So just food for thought.
Thank you, President Ussing. Counselor Fucillo.
Thank you, Madam Chair. I happen to agree with Councilors Ussing and Roby here. I think that in the same breath with the school committee appointment, I had gotten an opportunity to speak to some of the candidates before they had come before us, right? And so I would like to think that a future council would ask that question: do you plan to seek a full term on this seat, right? And obviously that person can change their mind and they could, tell us no and then run for that seat, right? That's a possibility. But I'd like to think that would be a part of kind of the council going through that process of figuring out who they're going to appoint. I know in the past the council's been deliberate in choosing the spouse of a councilor who's deceased or something along those lines, to ensure that we try to stay away from giving somebody an unfair incumbency advantage. But I'd like to think it'd be a very unique situation if that were to happen, and for those reasons I do support the way that the language is worded now. Thank you, Madam Chair.
Thank you, Counselor Fucillo. Any further discussion? Counselor Doucette.
Thank you. So I think there's a difference between at-large and ward, because at-large, it's a collection, 4 seats out of a collection. So having that get appointed seems to be reasonable. But in a ward seat, what I would do in this case is I would just say, whoever gets appointed can't run for the next term, next election. If they get appointed by the council, they can't run. They're a steward. They cover the rest of the term and then it's over. Okay, that's the change I would have preferred to see. Okay, that whoever gets appointed can't run for the next term for a ward seat.
Thank you, Councilor Doucette. I actually, so in my feeling and opinion, having not pulled papers for my seat for the next term, I didn't really see much interest in people filling this seat, but also the voting numbers are so dismal in the number of people who voted to elect me to this seat based on the number of people who are in the ward. I personally feel comfortable that in the last 12 months that this body would be able to appoint somebody, and I would really hope that it wouldn't give someone an unfair advantage because, like Councilor Roby had stated, I feel like somebody could unimpress people just as much as they could impress people. So I do continue to support this. And did you have any other comments?
I can't make any motion on this floor, so I can't make any changes at this point.
Oh, just for any
mean,
further comment?
Yeah, I stated my claim, right? I don't think that we should be making decisions that can impact a ward campaign. And the best way to do it is whoever gets appointed. This what, happened twice in 10 years? I mean, Bob Page and Don Landers, right? Twice in 10 years. Don died in January, Bob died in October, okay? But, so it's not a common occurrence, but it does happen. And I can't make any motions at this, but I do feel that, you know, the only way to make sure that the decisions on the council do not affect the ward voting is to basically say whoever gets appointed can't run for re-election, can't run for another, you know, they're elected to complete the term and not run in the following term. 2 years later, they can run.
So my concern about that is, what if that person is the only one who even wants the seat? Now we've basically said that they may not run.
So regardless of ward campaigns, what you're saying is, you know, sooner or later, someone has to run, okay? And trust me, I've seen what happened when, if no one's good's running, then yeah, you know, some people can get in that maybe shouldn't have gotten in. I'm not saying names or anything, right? But, you know, that is about making sure that people do get involved in politics, okay? But I still think you know, in a ward election, if the council appoints someone for a ward seat, that's going to influence the election, the next election. So,
Thank you.
and I said my piece and I'm done.
Okay. Councilor Roby.
I appreciate your input. I guess I would just, if you're that strongly thinking, you could always amend on the floor when this comes back to the council. But for me, and I know looking at the tapes when this was discussed, I think the last time around, the members of the council were conflicted. Do we make them not run? Do we let them run? And I don't remember, maybe Councilor Ossing does, I thought legal had said you can't tell them that they can't run. That's correct. You can't put that kind of a punishment on someone who is stepping forward to fill a vacancy. If they want to run, let them run and let them take their chances. Then once the vacancy is over and they start fresh again. So if you want to bring your motion in, fine, but I know I will personally be opposed to making that request. Thank you.
Councilor Petrillo.
Thank you, Madam Chair. And, you know, I agree, Councilor Roby. I would worry that even the kind of disenfranchisement of a single voter, right? You know, that person who would take that seat and ultimately be running for reelection or not running for reelection, you know, at the end of the day is a voter as well. And I think to bar them from running for office would be a slippery slope legally, especially for us as a city. On that same note, I would just encourage, I know there's a motion to approve the charter change, but to make sure it gets sent to the solicitor to be put in home rule petition form, and then to carry it over to the next legislative session. I figure we won't be able to suspend and report this out at the next meeting, but
Yeah,
yeah.
that's what I figured. She knew that that was the steps that had to be taken.
Sweet. Thank you.
I guess if you need that language added into it,
All good. Well, thank you, Madam Chair.
make sure that that's in your report.
Counselor Rossing?
No, I'm all set. Counselor Pacillo did a fine job.
Okay, so if there is no further discussion, a motion has been made and seconded. All those in favor? 3 in favor. The motion carries. And I will entertain another motion.
Madam Chair?
Counselor Pacillo?
Really quickly, thank you. I'm seeing that it's the end of December. This might be your last committee that you get to chair with us, so thank you for your leadership on L&L. And with that, move to adjourn.
A motion has been made and seconded to adjourn, and I thank Counselor Pacillo for his kind words. All those in favor? 3. Motion carries 3-0. The meeting is adjourned at 7:16.
Good evening, everyone. I'm going to call the City Council Urban Affairs and Housing Committee meeting to order. It's December 11th, 7:30. We have one item on our agenda, order number 25-109-540, a special permit application from Attorney Gemma Cashman on behalf of JC Residential and Light Commercial LLC for outdoor storage as an accessory use for the warehouse located at 1000 Nickerson Road. I believe Attorney Cashman is here if you want to come into the well, and if you have other people that you want to come with you, they're certainly welcome. If you would introduce them, please. And if you have any opening remarks, otherwise, I thank you for letting this go through to next year and for your patience as we've worked through all of this with the attorneys, the solicitor's office, and then trying to get this scheduled with people's schedules. So thank you.
Thank you. Gemma Cashman from Day Pitney, appearing on behalf of the applicant, JC Residential and Light Commercial LLC. With me tonight, I have two people from Lincoln Property Companies, Dante Angelucci and Connie Wigeranakula. I always struggle with that. Thank you. So I just want to make a few remarks tonight, just in light of all of the information that has developed, and just to remind the councilors of the project, since it's been quite a bit of time since we've appeared before you.
Sure.
So we're seeking consideration to grant a special permit pursuant to section 650-17, specifically for outdoor storage for purposes of an accessory use to support the applicant's adjacent use of the property. So first, I just want to remind the councilors that this is truly a non-nuisance use that will be screened from view. The project does not include expanding the existing building in any way. The outdoor storage area will merely just occupy a portion of the existing parking lot, and there will still be adequate parking on site. There's no changes to the vehicular traffic flow. Existing lighting will remain the same. There's be no new increase in noise or air pollution or changes to water, sewer. So really, this outdoor storage is truly a light non-nuisance use. The outdoor storage will be screened from the street. As we showed on the sightline views that we've previously provided, there'll be a fence. Storage areas will not be visible from the street. This is truly an ancillary use, and it's completely necessary for the applicant's business, and it can't be fully operational without it. Their occupancy will result in increased tax revenue for the city, so it's truly a benefit. And just to reiterate, we continue to agree with the current building commissioner's interpretation that our proposal meets the intent of section 650-18A, note 26. And on that note, I just want to emphasize our reliance on the building department's sign-off here. Both JC Residential and the Lincoln teams met with both the prior building commissioner as well as the current building commissioner on multiple and separate occasions, confirming that the outdoor storage is permitted with a special permit, and it's not only for manufacturing and assembly of vehicles. We had 2 meetings with them, with the current commissioner, Bill Payton. He signed our application without taking issue with this language. We've also received a building permit and TCO sign-off in August. And as you've seen, it's in your packet, there's an email from Commissioner Payton supporting his previous determination. And just to briefly touch on Massachusetts statutory law, case law, and the current Marlborough zoning ordinance, the building inspector's role here is truly the zoning enforcement agent. Mass General Laws, Chapter 143, Section 3 uses this language. Massachusetts General Laws 40A, Section 7. It really truly charges the building commissioner with the enforcement of the zoning ordinance, and they are the primary enforcement authority. That language is also mirrored in the zoning ordinance. There's also case law that talks about how the building inspectors truly have the inherent authority to make the zoning compliance determinations as part of their enforcement duties, including the power to determine whether a particular land use complies with the zoning requirements. So here, I just want to emphasize that JC Residential undoubtedly exercised appropriate due diligence and engaged in good faith reliance on a government official's representations and actions in our meetings, in signing on the application and issuing the building permit. Here we have a strong argument for equitable estoppel and detrimental reliance, as Mr. Angelucci will talk about in a minute. Here we truly had good faith and relied upon the building commissioner's actions, and we incurred extensive obligations and expenses that would be truly highly inequitable and unjust if our rights are taken away here. So the developer incurred permanent and substantial obligations that render enforcing the ordinance highly inequitable. So lastly, I just want to emphasize on why we disagree based on the interpretation of the city solicitor. So listening to the 2005 meetings and really looking into the true intent of the language here was to deter outdoor storage to protect the surrounding areas. I understand that there was comments from abutters, and there was true concern about, they don't want to litter the whole area with lots of outdoor storage and vehicles piling up and lighting and all these other nuisance obligations. So really, I think we just need to focus on that the purpose of the zoning ordinance here is to promote and conserve the health and general welfare of the inhabitants of the city. And the intent here is not to spread outdoor storage throughout the city. That's not the intent. The idea was to restrict it. And I do think that there can be a reading where light non-nuisance manufacturing is in and of itself a separate phrase. And if you look at the current zoning ordinance, that is, light manufacturing is a separate use. And when you look at automobile-related uses throughout the town and in the zoning ordinance, I mean, those uses aren't really allowed in the LA district now when you look at the language. So that deduction just doesn't make sense as the zoning ordinance reads today. So just to wrap it up and turn it over to Mr. Angelucci, I just want to emphasize that the true intent here behind the footnote was to protect the neighbors and the abutters from noise, 24-hour operation disturbances, and they discussed, yes, the car manufacturing in light of MHQ's use, and I understand that history, but the true intent here is to protect the neighbors from nuisance, and here we have a non-nuisance light manufacturing use. So respectfully, we're of the opinion that a full-scale use analysis is really not appropriate at this time. We went through that process with the building commissioner. He made it a determination and issued a building permit. It was not appealed, so we're here before City Council and whether or not we meet the test for granting a special permit, and I think we do. So turn over to Dante.
My name is Dante Angelucci, Lincoln Property Company. I'm here representing our tenant. Madam Chairwoman, members of the committee. Prior to us even executing a lease with the tenant, we went and met with the building commissioner to ask about this use, and at that time, he felt that the use was appropriate under the existing zoning, made that determination as chief zoning official. From that, we then went back, and additionally, we talked to him at that first meeting about the outdoor storage and the need of that for this specific tenant. The tenant made it very clear that that was something that they needed to have happen. Again, I think, at this point, it's really, it was detrimental reliance on what the building commissioner told us we could do. And we spent $1.5 million building out a space for a tenant who's probably going to leave. And frankly, the building was vacant for 2 years. It took us 2 years to find a tenant. We bring in a multinational tenant, which is a great thing for business in Marlborough and for taxes in Marlborough. And we had the second, affirmation from the building commissioner, who's currently in the position, again as a chief zoning official, making that determination yet again that it's an appropriate use for this site. And coming to the council to try and get this outdoor permit, which again was the premise by which we secured the tenant, that they believed that this was something that was allowed. The building commissioners told us it was allowed, and now we're in a position where we have still a very significant portion of this building vacant, and we're telling the business world that, the city officials can tell us something, we can go forward, sign a lease, come in and try and get the space to utilize it in the way that we told the building commissioner we were going to do it. And then the city's going to come back 6 months later and say, nah, you know what, we're not going to do that. And that's just not good business. And, frankly, if we lose the tenant, the building's going to be vacant for more than 2 years. And frankly, we're going to come back for tax abatements because the building's vacant, we can't use it. And we're not going to pay a tax base that's going to, be detrimental to us in terms of our existence as well. So again, I'm not making that as a threat. I'm just telling you that's a reality for a fiduciary responsibility to our investors. We're going to have to, and our partners, we're going to have to come back. Because again, we've paid the taxes for 2 years in good faith. We came forward with a tenant. We did the process the way we felt we were supposed to do the process, got that affirmation, had that conversation, secured a lease, and now our tenant is frustrated and upset about the fact that we're struggling to try and get the outdoor storage that they told us from day one we needed, and we received that indication from the building commissioner, who actually said that they would actually come and speak in favor of that as well at these meetings. So. That's essentially all I wanted to say. If there's any questions, we're happy to answer them. Thank you.
Thank you. Thank you. I appreciate both of you for your comments. I know this has been a lot of people looking at the tapes, a lot looking at the minutes. I had sent the information to all of the city councils, so they had the opportunity. I don't know how many of them actually reviewed. I know I have a differing opinion. It's 2025. This zoning change was done in 2005. I have no idea if up until now there have been applications that were denied from prior building commissioners. But to me, if this goes through, that means the potential for other manufacturers in LI to do outdoor storage is opened up, and that was not the intent of the council in 2005 to allow manufacturers to have outdoor storage. They made it very clear. So I guess I'm going to start off by not reading it entirely, but to read part of the letter we got from the solicitor. At issue is a matter of statutory construction, how to interpret the word and the underlined sentence above, which was, outdoor storage is allowed as an accessory use in a limited industrial district only for light nuisance manufacturing and assembly of specialized vehicles for use by municipal, state, and other public officials. One reading of the sentence is that in the LI, outdoor storage is allowed as an accessory use only to a use that is both light non-nuisance manufacturing and assembly of specialized vehicles for use by municipal, state, and other public agencies. Alternatively, and can be used in a descriptive sense where the word and implicitly repeats as the preceding word to each phrase, so that in the LI, outdoor storage is allowed as an accessory use only to a use that is light non-nuisance manufacturing and only to a use that is assembly of specialized vehicles for use by municipal, state, and other public agencies. In my opinion, both readings are possible, and it is necessary to consider the context and intent. When the intent is ambiguous from the words of a statute, a court looks to external sources such as legislative history and interprets the statute according to the intent from all its words considered in connection with the cause of the enactment so as to render the statute effective. He's citing City of Worcester versus Cole. The underlined sentence in Section 650-18A-26 was adopted as part of a zoning amendment in 2005. Section 650-18A-26 limits outdoor storage in LI in contrast to the B, C, A, and I districts by not allowing it to be an accessory to any permitted use, but rather to only a very specific use. In reviewing the 2005 discussion by the Urban Affairs Committee, including seeking opinions from city officials at the time, I find the intent was to create an ordinance that would narrowly limit outdoor storage to be accessory to a specific use and type of user that would manufacture vehicles for municipal, state, and public agencies. I understand the building department has provided its determination that outdoor storage is allowed by special permit, in this case as a principal use, qualifies as light non-nuisance manufacturing, and has a different interpretation of the section. Where ambiguities exist in the language of a zoning ordinance, a court is likely to give deference to a local board's reasonable interpretation of its own zoning ordinance because the local board is deemed to have special knowledge about the history and purpose of its zoning, so long as there is a rational basis. Again, he cites Petrillo versus the Zoning Board of Appeals. Accordingly, the City Council and its Urban Affairs Committee may consider how to apply Section 650-18A-26 to the pending application, consistent with the rules of statutory construction noted above. I also provided councilors with the comments that I had received when I requested information from 3 people who still reside in Marlborough who served on the City Council and were on the, 2 of them on the actual Urban Affairs Committee. Their comments from Mr. Clancy. I've had a chance to review the material and videos of the Urban Affairs meeting in 2005. The request to the council was for the relocation of a local business MHQ to a larger facility within the city. The facility was to be located in an already leased building on Elm Street zoned LI. Outdoor storage of vehicles, processed and unprocessed, was needed. A request to allow for storage would require a change in the zoning code. An amendment to allow it was introduced by Attorney David Gadboy to the council. The Urban Affairs Committee reviewed the request and approved the proposed language. It approved outdoor storage is allowed as an accessory use in a limited industrial district only for light non-nuisance manufacturing and assembly of specialized vehicles for use by municipal, state, and other agencies. There should be no separation of the word manufacturing and assembly. It all ties together. Only a business similar to MHQ would qualify or fit into this portion of the ordinance. They would have to be in the business of assembling vehicles similar to police or municipal vehicles. If any other clarification is needed, I'm always available to assist. And from Trish Pope, I had a chance to review everything last evening. I believe the permit was written, as written, was for an MHQ-type business only. The "and," in my opinion, indicates that both uses are tied together. Outdoor storage is allowed, I won't repeat, we keep repeating. Hindsight is 20/20, and although I asked at the meeting, this could be considered spot zoning. The language was written specially for an MHQ-type business only to give the ward councilors peace of mind rezoning all the LI. It was stated by Attorney Gadboy that this was not spot zoning. However, it was also stated that only an MHQ type of business is the only business that would meet the requirements of this rezoning, and to their knowledge at the time, there were no other types of business. Therein lies the problem. I believe if you were not present in 2005 and could be considered as tying two different statements together. And from Maura Naven Webster, thanks for reaching out and for sharing your notes in the minutes. As I recall, because of the concern that this change applied to all LI zones and not just the one in question, we were diligent in finding a solution that would not open the city up to an abundance of outdoor storage. That solution was a very narrow definition of the allowed storage and use. The word "and" is used to define one very narrow use inclusive of both characteristics rather than or and/or, which would seemingly allow for either use. I hope that helps. And then I put in the comments that I got from Bill Payton, the building commissioner. After considerable consideration and review of the Urban Affairs tapes of 2005, as well as the information provided from JC Residential and Light Commercial LLC, I am standing behind my zoning determination letter that they can apply for a special permit for outdoor storage as the business meets the requirement for light non-nuisance manufacturing. As I read the footnote 26 in Chapter 650-18, that the light non-nuisance manufacturing and the assembly of specialized vehicles for use by municipal, state, and public agencies are two separate and distinct items. I understand that Urban Affairs in 2005 was trying to limit as much as possible outdoor storage in the LI and I districts, and my interpretation of the zoning code still aligns with that limit, as there would be few instances that the light non-nuisance manufacturing would potentially require outdoor storage. And I will disagree with him because I will read the definition of light non-nuisance manufacturing as was pointed out by the petitioner. Light non-nuisance, as defined in Section 655 of the zoning ordinance, as fabrication, assembly, processing, finishing work, or packaging in such a manner that noise, dust, vibration, or similar objectionable features are confined to the premises, which opens us up to any manufacturer, in my opinion. I didn't read it, but Councilor Ossing, in replying to several emails that only went to myself and I think the solicitor, had commented I was present in 2005 and reviewed the tapes. I believe they are independent. They can be light non-nuisance manufacturing without being an MHQ. If the council believes there's an ambiguity in the wording, recommend a zoning amendment to clarify, which I would certainly agree with. We do have the we do have the draft, which was sent to us late. I do apologize for that, too. I noticed in the packet that we didn't have any draft special permit. I will quickly just go through the comments that we did receive from the department heads this evening, as they were kind enough to get that to us from the Marlborough Fire Department, the Police Department, and the Board of Health. They actually had no comments, neither did engineering. Priscilla Ryder from Conservation had suggested amending number 5 in the conditions, which is fencing, to add at this end of the fencing shall comply with the requirements of all applicable city ordinance, and then adding the words "and will require a fence permit from the building department." And the building department had replied that they agree with that addition. So I'm going to open it up if anybody has any beginning questions, comments, and if not, then I'm going to go through the special permit, and then we can open it up for discussion. Counselor Doucette.
Thank you very much, Madam Chair. So I see there's two issues here. First is, I hope Marlborough is business friendly enough we don't scare off businesses trying to get into Boston, to Marlborough. Put that on the table. Now, if we need to change the zoning to reflect reality of 2025, the nuisance assembly, manufacturing, what typically would end up happening, very similar to what they're probably going to do, is if it's being worked on, it's brought in the shop, and when it's done worked on, they put it outside, okay? They don't necessarily bring the tools out to that. They bring it inside to do the work. So what we should be doing is taking what was in 2005 and cleaning it up so that if someone wants to do light manufacture, light industry, and they want to do some outdoor storage, let them get a special permit. Have it come to us, whichever way it needs to be. And then we figure it out from there, and we call the shots. What this is showing is we got to do something like that to clean it up. Okay, but I don't want to scare these guys out of town. So that's all I need to say.
Any other comment? Counselor Fucillo?
Thank you, Madam Chair. Completely agree with Councilor Doucette there. I think if there's something to be cleaned up, right, it shouldn't be at the expense of this in particular case, right? That's something we have to do outside of this. I agree with the interpretation that "and" is distributive. The fact that it is not, these are not a joint case, right? A light non-nuisance manufacturing in this case is what we're looking at. And so I think, we can look at this project on its own merits, go through the special permit, and I would be in favor of this. So with that, I turn it back to you. Thank you, Madam Chair.
Any further comments, questions? All right, I'm quickly going to go through the decision of the special permit. It is a City Council of the City of Marlborough grants the application for a special permit to JC Residential and Light Commercial LLC, having a usual place of business at 2443 Ash Street, Palo Alto, California, as provided in the decision and subject to the following findings of facts. The applicant, JC Residential and Light Commercial LLC, is a limited liability company organized under the laws of the state of Delaware, registered as a foreign limited liability company in the Commonwealth of Massachusetts, having a usual place of business at 243 Ash Street, Palo Alto. The applicant's the current tenant, the building located at 1000 Nickerson Road, Marlborough, Massachusetts, as shown on the Marlborough Assessor's Map 88, Parcel 36, the site. On August 14th, 2025, the applicant filed with the City Clerk of the City of Marlborough an application to City Council for issuance of the special permit, hereinafter referred to applicant. I will note that the packet indicates that this was date stamped on the 15th. The letter's dated the 14th, so I'll let the solicitor decide which date should be in here. But under Article 5, Section 650-17 of the City of Marlborough zoning ordinance, the applicant proposes outdoor storage as an accessory use to one of the permitted uses in the zoning district in which the main building and lot is located, warehousing and light non-nuisance manufacturing. Site's located in the LI zoning district as shown on the plans referenced in paragraph 7. The use will consist of an outdoor storage area that will occupy a portion of the existing parking lot at the site, which will be secured with a 12-foot chain link fence with mesh, the project. In connection with the applicant submitted an application to the City Council for issuance by special permit, the filing fee, special permit, I missed the abutters list, the special permit application certification, tax payment, and authorization letter from the owner, and the site plan dated August 7th, 2025. The applicant was certified as complete by the building commissioner of the city. Site has an area of 12 plus or minus acres as shown on the plans, and pursuant to the rules and regulations of the City of Marlborough, the City Council established October 6th as a date for a public hearing, and the city clerk caused to be advertised notice of said hearing. City Council opened the public hearing on October 6th and closed the public hearing The applicant, through its representatives, presented testimony at the public hearing detailing the use, describing its impact upon municipal services, the neighborhood, and traffic. At the public hearing, no members of the public spoke in favor or opposition. Based on the following, the City Council makes the following findings and takes the following actions. The applicant has complied with all the rules and regulations promulgated by the City Council as they pertain to special permit applications. City Council finds that the proposed use at the site is an appropriate use and in harmony with the general purpose and intent of the zoning ordinance when subject to the appropriate terms and conditions as provided herein. The City Council makes these findings subject to the completion and adherence by the applicant, its successors, and/or assigns to the conditions more fully set forth herein. City Council, pursuant to its authority under MGL Chapter 40A, grants the applicant a special permit for outdoor storage as an accessory use, subject to the following conditions. Number one, construction in accordance with applicable law. Construction of all structures on the site shall be in accordance with all applicable building codes and zoning regulations in effect in the City of Marlborough and the Commonwealth of Massachusetts, and shall be built according to the plans. 2, modification of plans. The City Council may approve engineering plan changes to the plans, so long as said changes do not change the use as approved herein, or materially increase the impervious use of the area, reduce the green area, alter traffic flow, or increase the size of the building, all as shown on the plans. Any modification of the conditions of this special permit or the use as approved herein shall first require modification of the special permit. Number 3, compliance with applicable laws. The applicant shall comply with all applicable municipal, state, and federal rules, regulations, and ordinances. They may apply to the construction, maintenance, and operation of the project and the use at the site, including without limitation compliance with local Conservation Commission orders, the Massachusetts Environmental Policy Act, and the State Building Code. Number 4, incorporation of submissions, all plans, photo renderings, site evaluations, briefs, and other documentation provided by the applicant as part of the application and as amended or revised during the application hearing process before the City Council and/or the City Council's Urban Affairs Committee are herein incorporated into and become a part of this special permit and become conditions and requirements of the same unless otherwise altered by the City Council. Number 5, fencing. In accordance with Section 615-18A 48 of the zoning ordinance, the applicant shall install solid fencing to screen areas of the site used for the storage of equipment and materials from the street and adjacent properties, and shall maintain the fencing in good repair. The fencing shall comply with the requirements of all applicable city ordinances. Does anybody have an objection to adding in the and will require a fence permit from the building department?
So moved.
Commissioner is okay?
Yeah.
Adding in that, all right, so I will make sure that that is noted. Number 6 is signs. Signage at the site shall comply with the city's sign ordinance. Number 7, noise and air quality. The applicant shall comply with the city's noise ordinance and shall comply with all state and federal requirements governing air quality and emissions. Number 8, water supply protection district. Applicant shall comply with all requirements of the city's water supply protection district, and this decision does not authorize any exception to the prohibitions on uses and requirements of said ordinance. And number 9 is our typical recording of decision. So, with that, I will...
Motion to approve as amended.
All right, it's been moved and seconded to approve. I will open it up for comments for committee members, for anybody else. Councilor Ossing?
Thank you, Madam Chair. I do appreciate your efforts, Madam Chair, on the subtleties of the wording. But I think it's pretty clear. We've got 2 building commissioners that have stated it's acceptable. The solicitor, he put his opinion down, but basically said it's going to fall on the determination of the building commissioner, who is the zoning enforcement officer. I was on the committee, or I was in the council in 2005. I was not on the committee. And I know Attorney Gadboy said it wasn't spot zoning, but they worked very hard to craft it such that you could have light non-nuisance industrial manufacturing and the MHQ. And I think the testament has been no one's actually asked for this at least since 2005, from my standpoint, I don't remember any special permit coming before us asking just fence and store anything outside. And it's a good company, it's filling a vacant building, we just set the tax rate, we need tax revenue. To hold this up because of some, discussions or interpretations of the word "and," I don't think would be appropriate. I think what would be appropriate is move this thing through on its merits, and if we think the word is "and" and we think there's gonna be a rush to store stuff outside, let's submit a zoning change and just clarify it. I mean, but I wouldn't hold this one up. I mean, this one, if you've been up to the 1000 Nickerson, you can't see it, it's up on a hill, there's 40 to 50-foot pine trees all around, so you can't see it from Route 20, Hayes Memorial, or Nickerson, and then we're gonna have them put a fence around it, because the rules say we have to, which I get, but you just can't see it. And it's a good company that, personally, I want in Marlborough to be here. So for that, Madam Chair, I hope the council looks the Urban looks favorably on the zoning change, and I would encourage, if we're really concerned about that wording, let's put a zoning change in. We've got that power to do that, and we'll just fix it. We'll just cross it out or fix it whatever way we want. I think that would be appropriate. Thank you, Madam Chair.
Thank you, Councilor Ossing, and I do appreciate your comments. I also appreciate the fact that we need funds, but I think as soon as we approve this, we don't need to change the zoning because the current building commissioner has already said they're two separate things. So any other light manufacturing permit that comes in, he's going to approve and he's going to move it forward. And I believe you are wrong. I think the solicitor's letter says it's the local board's reasonable interpretation of its own zoning ordinances. So to me, a reasonable interpretation is what the 2005 Urban Affairs and City Council approved, and 3 members from that council have stated that it was very clear that the "and" combined the two, but did not separate them into 2 separate things. So I'm sticking with my opinion. I had a conversation with Councilor Preciado. He apologized for not being able to come. He also supports no on this. It's not clear. I did have a conversation with Councilor Navin, but I don't want to put words in his mouth because he didn't give me a yes or no. He just seemed like he was leaning toward a no. But I am hoping that the council votes no, and if we want to go and change this, I would almost prefer that we change it back to no storage in LI, even if it creates a pre-existing non-conforming use, because rumors are that use is going to go away. Rather than allowing outdoor storage in LI, because I don't want to see outdoor storage, neither did the 2005 council. So I'm adamantly opposed to that. But with that, I will allow Councilor Brown, I think she's the one who hasn't spoken yet, and then I'll go back to you, Councilor Ossing. Thank you.
Thank you, Madam Chair. When I look at this, this request for me, I'm just looking at this request from this body in front of us here, and this is in my neck of the woods. I live down on that end of town and very, very familiar with the area, and I really appreciate that, there's a tenant that wants to come in and utilize the space, and I feel like this for me makes sense for that area, and so for this particular ask, I would vote in favor of it. And as President Ossing had stated, that if the council or committee feels strongly about the wording, to then pursue a zoning change in the future. Thank you.
All right, Councilor Ossing, did you have further comments?
Yeah, but I want to give everyone else a chance.
I'm sorry, I was
Actually,
looking this direction.
Councilor
so-
Ficcello was going to speak. Let him go first.
Councilor Fricillo.
Thank you, Madam Chair. Thank you, guys. Just real quick, that I appreciate kind of the perspective we've been given and gone back and watched the video from 2005. But even looking there, I feel like in 2005 there was real abutter concern about that particular project, right? Maybe they were looking, beyond that too, citywide, sure, but I think the main concern was to limit the use to protect the neighbors at the time, and I really think we're far from that in this case, right? That we're just not seeing that. This is a non-nuisance use. It's screened from the neighbors, like President Ossing said. There's no light trespass. There's no additional building being created in any way. It's going to be fenced, but also has that natural barrier of the trees. So again, kind of like Councilor Brown you had mentioned, just looking at this based on its merits, I think this is a really strong project, and I stand in the affirmative to approve this tonight. Thank you, Madam Chair.
Councilor Doucette.
Thank you very much, Madam Chair. So the outdoor storage immediately got me thinking about the airport, because there's a whole bunch of outdoor storage. It's called contractor yards, but still, and it's light industry area. I think that, these guys should be allowed to enter our city and provide jobs, okay? I think that what they brought up is something that we need to address and we need to fix, but it shouldn't impede them. We need to go back and do our homework as far as fixing the wording to be either and or something, and make it drive to a special permit versus just letting the building inspector approve it. Because in the case of, Nickerson Road, where it's in an industrial area, there's no neighbors, right? So it doesn't matter much. The airport has a handful of neighbors, no one cares. But if they're gonna put it someplace, off of Concord Street or one of the other streets, different conversation to have, right? But, like some other part of light industry zone that does have some neighborhoods adjacent to it. Not necessarily that one, but, just making sure that we can supervise it and either accept it or deny it, okay? And in this case, I think there's no reason why we should not accept it. It's in the middle of light industry, it's surrounded by other businesses. Let them do what they want, let them bring the jobs into the city. Thank you.
Any further comments? Councilor Ossing.
Thank you, Madam Chair. So again, I know you got comments from some of my peers in 2005. Doesn't mean I have to agree with their perspective. Again, you've all looked at the tape and you've all drawn your own opinions. There's no rush of applicants looking to do outdoor storage. So if we want to change the zoning, this is where I'll disagree with you. Change the zoning, put a zoning change in the beginning of January to say no outdoor storage. The ones that are approved are grandfathered in, and then there'll be no more outdoor storage in limited industrial. I mean, if you feel that strongly about it, but there is no rush on people to ask the city council for permission to do outdoor storage in limited industrial. There just isn't. We've got a good company that's following the rules that the zoning enforcement officer said is okay to do. I think we're getting hung up on some wording issues that I don't believe are there, because I still go back to, I disagree. There was a big discussion on spot zoning, and those words were put in there to help eliminate the fact that we weren't doing it just for MHQ. And we'll all have our own interpretations of that tape, but I was there, and I just disagree, but that's okay. But I would encourage Urban Affairs and the council to support this special permit. Thank you, Madam Chair.
Thank you. So I guess we can all agree to disagree and have our own opinions, and see where this goes as it comes back through. My plan is to report this out on Monday once the vote is taken. There are 2 committee members missing, so it will be a vote of the 3 of us that are here. But report it out, carry it over to next year, suspend the rules on Monday so it can be referred to the solicitor to be put in proper form, so he may make some changes. And then at the second meeting in January, the date to be determined by whoever is president, and when the calendar is set, the council would then vote on this. So that's kind of the procedure of where we are at this point. So further comments? All right, hearing none. All those in favor of approving as amended? Recommending approval. So 2, and I will vote opposed. And as I said, I will get a report written up, and this will be on the agenda for Monday. You're certainly welcome to come, but you don't have to, and then we'll let you know when that calendar is set for when this will be back on the agenda.
Motion to adjourn.
It's been moved and seconded to adjourn. All those in favor? All right, we are adjourned at 8:10. Thank you.